Welcome to the Contract Bank. I am business attorney Roxanne Smithers. This video is going to discuss the Master Artistic Performance Agreement. We're providing terms and conditions for artists and performers for their relationships with their clients. It's set up as a master agreement in the event that an artist has an ongoing relationship with a customer or with a venue, and they want to be able to have clear, consistent terms to that relationship, and then utilize a scope of services or a schedule of services to lay out the specific details of each project or of each performance. So let's get into this agreement. To start, we have section 1, which is the scope of services section. And this section provides some initial general information about the relationship and what the artist is going to be doing for the client. As I mentioned, the specifics of each performance or each project or engagement will be detailed in a services schedule that's at the end of the agreement. You can use multiple services schedules with one master agreement in place. Okay. Section 2 is going to cover fees and expenses. This details some of the information with regards to how you're going to be paid as the artist, as well as any expenses or costs that the customer, your client, are going to reimburse you for or will be responsible for as part of your performance or as part of the project. So that could be if it's got to be at a specific location, you have to have special equipment, if you have to have special attire or costuming or props that the client wants you to use, you may include those as an expense if you're able to negotiate that with your client. Next, we're going to have section 3, which actually covers, as I was discussing, equipment and access. So this details that if there is any specific equipment that you're required to utilize, it is up to the customer to provide that equipment, unless of course they're going to reimburse you for acquiring that equipment. The customer, the client, will also be responsible for providing you with access to the space or location for the performance. If you need rehearsal time, if you need blocking time, other like planning time that you need to have in the space, the client will be responsible for making sure you have the necessary access for you to provide the agreed upon performance. Section 4 details rights with regards to advertisement and merchandising. So it contemplates that most advertisements will be created by the client or on behalf of the client. The client may be using other vendors for those services. But those marketing materials will be subject to your written approval, particularly if they're going to be using your name, your likeness, or any information or content about you in those advertisements. You are also providing the client will also be providing you with an opportunity to sell any merchandise at the performance, and you will retain those proceeds and any sales that come from that. Of course, the client may push back, and this may be a provision that you need to negotiate with a client, but we've got this initial language in here that benefits the artist. Section 5 covers recording and reproduction of the performance, and it specifically says the client will not have any right to record, to broadcast, or stream your performance without your written consent. Section 6 covers intellectual property rights and makes it clear that you own the rights to your performance, and that you will have the opportunity to issue any licenses to the client to utilize your performance or the content thereof in the future. Section 7 details if the client wants to cancel the performance, depending on the timeline of when they cancel the performance, what their obligations are in terms of notice and in terms of compensation to you. This section also details what happens if you need to cancel or are not available for the performance. Section 8 deals with acts of God, force majeure, If there is an event that is beyond either you or the client's control that prevents the performance, this details what happens in such situations, what amount you're paid, what the client is obligated to do, what your obligations in terms of a future performance or rescheduling. Section 9 makes it clear that the client is responsible for your security and safety, as well as any equipment that is utilized for the performance. Section 10 details that the client is responsible for providing you with a comfortable and private dressing room and shall supply hospitality items as detailed in the services schedule. Gives you an opportunity to put together a rider of what you will need to have on the day of the performance to make you comfortable backstage. Section 11 makes it clear that the client is responsible for any insurance that's necessary for their operations and for the event and for the performance. You do have a right to require that the client provide you with their certificate of insurance. Section 12 covers the duration of this agreement or the term, and it also details how either party can terminate the agreement. This section additionally provides for what happens if the terms of this agreement are terminated while you still have schedules of service or projects that are pending between the parties. Section 13 is what we call a limitation of liability. This provision puts both a dollar amount cap on the amount of damages for which you could be liable to your client, and it also puts a cap on the type of damages for which you may be liable to your client. Section 14 is an indemnification provision. This provision makes clear that both parties are agreeing that if the actions or inactions of one party cause a damage or loss to the other party, they'll be responsible. For example, if your client secures a venue but does not get the proper permitting, proper permissions for that venue for the performance, or if your client requests that you utilize music for the performance that they have not received the right clearances or permissions to utilize, and a claim is brought against you, your client will be responsible. They will have to indemnify you, reimburse you for any damages that you incur, take responsibility for defending against the claim. Section 15 and 16 covers the nature of the relationship. You are an independent contractor and not an employee of your client. You are free to provide services to other customers or clients, and your client is free to obtain services from other artists. This is not an exclusive relationship. Section 17 and 18 deal with how disputes are resolved. 17 details the law that governs the dispute and governs the contract, and 18 details the process of resolving a dispute. The parties have the opportunity to negotiate a resolution, then to mediate a resolution, and if all else fails, they have the option to arbitrate their claims. Section 19 covers the process by which formal notice of any issues with the contract are provided between the parties, preferably in writing. Sections 19 and 21 are guideposts for either a judge, a jury, or an arbitrator in terms of how to apply the terms of this agreement to your dispute. And then finally, Section 22 makes it clear that this written agreement is the full universe of terms and obligations between the parties, and that if you want to make any changes to this agreement, they have to be in writing and agreed to by the parties. At the end of the standard terms of this agreement, we have that schedule of services, or that services schedule. This is where you'll detail the specifics of a performance or the specifics of a project that you will be working on with the client. Detail the performance, the date, the location, the time, any equipment that the client is going to provide, mics, speakers, costuming, anything of that sort. This document also lays out your payment options, whether you're paid a flat fee when it's due, if deposits are required, when those deposits are due, any additional expenses for which you will be reimbursed. This details also that if you give permission for the client to record and utilize the performance, we have a rider for that. It also details what happens if the client looks to cancel, or if you look to cancel, and the timelines by which you can cancel and receive a prorated payment. This document also gives you that opportunity to provide your hospitality rider, the things that you require in your dressing room for the performance. And then finally, there's an opportunity to detail any one-off modifications to the master agreement that are going to apply specifically to this performance. We then follow that up with that permission to record and release rider, where you are giving the client specific levels of permission to utilize your performance. There are options to store it for archival purposes, viewing within the organization, viewing outside of the client's organization, displaying on the client's website, posting to the client's social media accounts, disseminating to the public and third parties, including the media, distributing and authorizing use for commercial purposes, and any other licenses that are negotiated between you and the client. So this is a quick overview of the Master Artistic Performance Agreement. If you decide to purchase this agreement, you will receive both a PDF as well as an editable Word version of the agreement that you can utilize with your services. And I want to thank you for visiting me in the Contract Bank, and I'm your business attorney, Roxanne Smithers.